Everyone knew her as America's beloved daytime television host. But when Ellen DeGeneres stood up in federal court that day, she was about to reveal a secret she had kept hidden for over 2 decades. Not just comedic brilliance, but deep civil rights law expertise, years of studying constitutional equality protections, mastery of anti-discrimination jurisprudence. Attorney General William Barr was dismissing her as just a talk show host playing activist, unaware that standing before him was someone who understood civil rights law better than most federal prosecutors. Ellen's first legal argument alone would completely transform the courtroom atmosphere. "Your Honor, Attorney General Barr," said Ellen, her voice carrying the same warmth that had connected with millions, but now focused with legal precision. "May I speak to you about the Equal Protection Clause's relationship to LGBTQ+ rights and the constitutional limits on federal discrimination enforcement?" What happened that day in the Los Angeles federal courthouse would revolutionize both civil rights law and our understanding of constitutional equality protections. Before diving into this extraordinary fictional legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance challenging established authority. Barr's World, Traditional Legal Authority. Attorney General William Pelz. Barr represented the conservative federal law enforcement establishment. At 74, the former Attorney General had built his reputation on strict law and order policies and skepticism toward expansive civil rights interpretations. A Columbia Law graduate with decades of Justice Department experience, Barr embodied traditional prosecutorial approaches to constitutional law. His prosecutorial philosophy emphasized law enforcement authority and limited expansion of civil rights protections beyond what he viewed as explicit constitutional text. Barr particularly questioned whether LGBTQ+ rights deserved the same constitutional protection as traditional civil rights categories. That day, his assumptions about Ellen DeGeneres were predictable. Yes, Ellen was extraordinarily successful in entertainment. Yes, she had become a cultural icon for LGBTQ+ visibility. But in Barr's view, she was simply another celebrity using legal rhetoric to advance political agenda, rather than a serious advocate for constitutional rights. This assessment would prove to be a fundamental miscalculation. Ellen's hidden journey. From comedy to constitutional law. The world knew Ellen DeGeneres through her entertainment evolution and cultural impact. From stand-up comedy to groundbreaking television representation, from coming out publicly to becoming a daytime television phenomenon, her influence on LGBTQ+ visibility and acceptance had been transformative. With decades of entertainment success and billions in cultural impact, Ellen had become one of the most influential figures in modern media. But what the public didn't know was that Ellen's experience with discrimination and her commitment to equality had sparked an intensive intellectual curiosity about the legal frameworks governing civil rights and constitutional protections. Starting in 1997, after facing career consequences for coming out, Ellen had begun serious study of civil rights law and constitutional equality principles. "I realized that visibility isn't enough," she had confided to her wife Portia during one of their evening conversations. "If we're going to protect LGBTQ+ people and all marginalized communities, I need to understand the legal system that either protects or fails to protect our fundamental rights." Working with civil rights law professors from UCLA and Stanford, Ellen spent her time between television projects studying Supreme Court equality precedents, anti-discrimination law, and the constitutional foundations of civil rights protection. She completed advanced coursework in constitutional law, civil rights litigation, and the intersection of equality with democratic governance. By 2023, when the case that would bring her to federal court emerged, Ellen wasn't just defending LGBTQ+ visibility. She was also a well-educated advocate for constitutional equality, with genuine expertise in the civil rights law that governed anti-discrimination enforcement and constitutional protection. The Case Foundation: Equal Protection versus Religious Liberty. The federal case that brought Ellen DeGeneres before Attorney General Barr represented one of the most significant civil rights challenges of the modern era. DeGeneres vs. Department of Justice challenged the federal government's enforcement priorities in civil rights cases as violations of both equal protection principles and constitutional due process. The case had emerged when Ellen filed a comprehensive civil rights lawsuit claiming that the Justice Department under Barr had systematically deprioritized LGBTQ+ discrimination cases while aggressively pursuing religious liberty exemptions that undermined anti-discrimination protections. She argued that this enforcement pattern violated constitutional equal protection guarantees. The implications extended far beyond Ellen's situation. If her legal theory prevailed, it would establish new constitutional requirements for equal enforcement of civil rights laws and limit the government's ability to prioritize some discrimination claims over others. If the Justice Department won, it would confirm that federal agencies had broad discretion in civil rights enforcement without constitutional constraint. For Barr, this case represented an opportunity to defend traditional religious liberty protections while maintaining prosecutorial discretion in civil rights enforcement. He viewed it as a matter of balancing legitimate religious freedom with anti-discrimination enforcement. For Ellen, the case was about fundamental constitutional principles, whether the Equal Protection Clause required equal enforcement of civil rights laws, and whether the government could constitutionally prioritize religious exemptions over anti-discrimination protections. The setting: Los Angeles Federal District Court. The modern courtroom of the U.S. District Court for the Central District of California was packed with civil rights advocates, constitutional law scholars, and LGBTQ+ rights organizations. This case had drawn national attention both because of Ellen's celebrity status and its potential impact on civil rights enforcement and constitutional equality. At the plaintiff's table sat Ellen DeGeneres, dressed in a sharp navy blazer that projected legal seriousness rather than television entertainment. Her legal team from the ACLU and Lambda Legal flanked her, though Ellen had insisted on presenting key constitutional arguments herself, a decision that had surprised civil rights law experts. At the defense table, the Department of Justice had assembled their most experienced civil rights attorneys, led by Assistant Attorney General for Civil Rights Division Sarah Mitchell, a Harvard Law graduate with extensive experience in constitutional litigation. Behind them sat federal prosecutors and Justice Department officials, all confident this would establish important precedents protecting prosecutorial discretion. Attorney General Barr, attending this case due to its significance for federal civil rights policy, had already made his skepticism about celebrity constitutional claims clear through his previous public statements and enforcement priorities. First contact: the dismissive challenge. Ms. DeGeneres, Attorney General Barr began, his voice carrying the authority of federal law enforcement, "This court recognizes your entertainment accomplishments and cultural influence. However, civil rights law involves complex constitutional principles and sophisticated enforcement considerations. Are you prepared to engage seriously with established legal doctrine rather than asserting emotional appeals about discrimination?" The question was designed to highlight what Barr saw as the fundamental difference between cultural advocacy and legal expertise. His tone suggested he expected Ellen to rely on her legal team or demonstrate the kind of constitutional superficiality he associated with celebrity activism. Ellen stood deliberately, her posture respectful but confident. "Mr. Attorney General, I understand your concern about legal complexity. However, I'd like to address that concern by discussing the Supreme Court's analysis in Yickwo v. Hopkins and how equal protection requires not just facially neutral laws, but equal enforcement of those laws." A surprised murmur went through the courtroom. This wasn't the celebrity activism Barr had expected. "The Equal Protection Clause," Ellen continued, "prohibits not just discriminatory laws, but discriminatory enforcement of neutral laws. When the Justice Department systematically deprioritizes LGBTQ+ discrimination cases while aggressively pursuing religious exemptions, it violates this fundamental constitutional principle." Barr's expression shifted slightly. The response demonstrated actual understanding of constitutional civil rights doctrine, not just cultural advocacy talking points. Testing the constitutional waters. "Ms. DeGeneres," Barr continued, his tone becoming more serious, Citing historical cases is one thing. Understanding how modern civil rights enforcement balances competing constitutional values is quite another. Are you familiar with how contemporary courts evaluate prosecutorial discretion in civil rights contexts? This was the kind of question designed to separate constitutional amateurs from serious civil rights scholars. Ellen nodded confidently. Absolutely, Mr. Attorney General. The court's framework in McCleskey v. Kemp establishes that prosecutorial discretion receives constitutional deference, but this deference has limits when enforcement patterns demonstrate systematic discrimination based on protected characteristics. Barr leaned forward, his interest clearly piqued. Continue with your constitutional analysis. The Justice Department's enforcement pattern, Ellen proceeded, violates McCleskey's limits because it demonstrates intentional discrimination against LGBTQ+ people through systematic deprioritization of their civil rights claims. When enforcement discretion serves discriminatory purposes, it exceeds constitutional bounds. The courtroom had grown quiet. Civil rights reporters were taking detailed notes, and even the Justice Department's attorneys were paying close attention to this unexpected constitutional discourse. The revelation: Ellen's civil rights expertise. Ms. DeGeneres, Barr said, his tone now markedly different from his initial dismissiveness, your constitutional analysis of civil rights enforcement demonstrates considerable legal sophistication. Where did you develop this expertise in equality law and constitutional civil rights? Ellen's response would reveal the depth of her legal preparation. Mr. Attorney General, I've spent over 25 years studying civil rights law and constitutional equality principles, initially through UCLA Law's public interest program, later through private study with constitutional scholars specializing in anti-discrimination law and equal protection theory. I've worked directly with Professor Devin Carbato at UCLA on constitutional equality theory, studied under Professor Kenji Yoshino at NYU on LGBT+ constitutional rights, and completed advanced coursework through Stanford's constitutional law program focusing specifically on the intersection of civil rights enforcement, prosecutorial discretion, and constitutional equality. The courtroom buzzed with surprise. Barr himself looked genuinely taken aback. Moreover, Ellen continued, my practical experience facing discrimination and advocating for LGBTQ+ rights has given me unique insight into how constitutional principles translate into real-world civil rights protection. I've seen firsthand how enforcement priorities can either advance or undermine constitutional equality. Barr's deeper constitutional challenge. Barr, now taking Ellen's arguments seriously, decided to test the deepest level of her constitutional understanding. Ms. DeGeneres, your case essentially argues that prosecutorial discretion cannot consider religious liberty protections when they conflict with anti-discrimination enforcement. But how do you address the legitimate constitutional balance between equal protection and free exercise rights? This question went to the heart of modern constitutional law, the sophisticated balance between competing constitutional values that typically separated legal generalists from serious constitutional scholars. Ellen's answer would demonstrate whether she truly understood the complexities of constitutional law in the civil rights context. Mr. Attorney General, there's a crucial distinction between protecting genuine religious exercise, which the Constitution requires, and allowing religious liberty claims to trump equal protection enforcement, which violates constitutional balance. She paused to organize her constitutional argument. The Supreme Court's decision in Employment Division v. Smith established that neutral laws of general applicability don't violate free exercise even when they burden religious practice. Civil rights laws are exactly such neutral laws of general applicability. Barr was now fully engaged with Ellen's constitutional analysis. You're arguing that religious liberty cannot excuse discrimination prohibited by civil rights laws? No, I'm arguing that when the Justice Department prioritizes religious exemptions over equal protection enforcement, it violates constitutional balance by elevating free exercise above equal protection, Ellen responded. The Constitution requires that both clauses receive equal respect, not that religious liberty always trumps equality. The precedent analysis Building civil rights. Constitutional framework. Moreover, Ellen continued, we have direct precedent for limiting religious exemptions when they conflict with anti-discrimination principles. The Supreme Court's decision in Bob Jones University v. United States held that religious institutions cannot claim tax exemptions when their practices violate fundamental public policy against racial discrimination. Barr was taking careful notes. How does Bob Jones apply to LGBTQ+ discrimination? Bob Jones's constitutional principle applies directly to contemporary civil rights enforcement, Ellen replied. The court recognized that some anti-discrimination principles are so fundamental to constitutional equality that religious objections cannot override them. Sexual orientation and gender identity discrimination violate equally fundamental constitutional principles. Ellen then presented her most sophisticated constitutional argument. The court's recent decision in Masterpiece Cakeshop v. Colorado Civil Rights Commission confirms that religious liberty and anti-discrimination protections must be balanced, not that religious claims automatically prevail. When applied to federal enforcement, this means the Justice Department cannot systematically prioritize religious exemptions over equal protection. Barr's constitutional recognition. The change in Attorney General Barr was evident to everyone in the courtroom. His initial skepticism had evolved into genuine engagement with Ellen's constitutional arguments. Ms. DeGeneres, Barr said, I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented civil rights arguments that merit serious consideration from this administration. Thank you, Mr. Attorney General, Ellen responded. I hope this demonstrates that constitutional civil rights principles belong to all Americans who experience discrimination. Equal protection isn't just legal theory, it's the foundation of democratic equality. Barr nodded thoughtfully. Your argument essentially contends that federal civil rights enforcement must serve constitutional equality rather than prosecutorial convenience or political priorities. This raises fundamental questions about the relationship between law enforcement and constitutional rights. The government's constitutional defense assistant Attorney General Mitchell, representing the Justice Department, attempted to refocus the constitutional conversation. Your Honor, while Ms. DeGeneres' constitutional studies are noteworthy, the fundamental issue remains prosecutorial discretion. The Justice Department must balance limited resources against competing enforcement priorities. Barr turned to Mitchell with new interest in the constitutional balance. Counselor, how does the department respond to Ms. DeGeneres' argument that systematic enforcement patterns can violate equal protection even when individual prosecutorial decisions receive deference? Mitchell found herself defending Justice Department practices against sophisticated constitutional arguments rather than dismissing celebrity activism. Mr. Attorney General, prosecutorial discretion has traditionally received broad constitutional deference from federal courts. Ellen was prepared for this constitutional response. Mr. Attorney General, the government's prosecutorial discretion argument ignores the constitutional principle that discretion cannot be exercised in ways that violate fundamental rights. In Batson v. Kentucky, this court held that prosecutorial discretion cannot be used to exclude jurors based on race. The same principle applies to civil rights enforcement. Constitutional framework development. Ellen then presented her proposed constitutional solution. I suggest a framework that protects both prosecutorial efficiency and constitutional equality. First, enforcement priorities must serve constitutional rather than political purposes. Second, systematic deprioritization of any protected group's civil rights claims requires compelling constitutional justification. Third, religious liberty accommodations must be balanced against rather than prioritized over equal protection enforcement. Barr engaged directly with this constitutional framework. How would your framework address practical concerns about resource allocation and enforcement efficiency? The framework protects enforcement efficiency while ensuring it serves constitutional purposes, Ellen responded. Rather than systematic discrimination, the Justice Department can develop resource allocation that promotes rather than undermines constitutional equality. The Constitution requires this approach because civil rights enforcement exists to serve equality, not convenience. Ellen concluded with her strongest constitutional argument: equal protection means equal enforcement. When the Justice Department treats some American civil rights as less important than others, it violates the constitutional promise that made civil rights laws possible in the first place. Barr's final constitutional assessment. As the hearing concluded, Attorney General Barr addressed Ellen directly. Ms. DeGeneres, your constitutional arguments today have been remarkable. You've demonstrated understanding of civil rights law and constitutional equality that rivals the most experienced civil rights advocates. Thank you, Mr. Attorney General. This case has never been about attacking law enforcement or religious liberty. It's been about ensuring that constitutional civil rights receive the equal protection that the Constitution promises to all Americans. Barr reflected on the broader constitutional issues. Your arguments raise fundamental questions about the relationship between enforcement discretion and constitutional equality. This administration will examine them with the constitutional seriousness they deserve. The landmark civil rights decision. 2 weeks later, the federal court issued a comprehensive 43-page decision that would reshape civil rights enforcement and constitutional equality jurisprudence. The ruling found that the Justice Department's enforcement patterns violated equal protection principles and required new guidelines ensuring equal priority for all civil rights claims. More significantly, the court's opinion adopted key elements of Ellen's constitutional framework, creating new precedent for how federal agencies must balance enforcement discretion with constitutional equality requirements. The decision included an extraordinary judicial acknowledgement. This case demonstrates that constitutional wisdom about civil rights often emerges from those who have lived the practical effects of discrimination. Ms. DeGeneres' analysis has contributed meaningfully to this court's understanding of equal protection requirements in civil rights enforcement. Broader constitutional and social impact. The DeGeneres v. DOJ decision created immediate changes in federal civil rights enforcement and sparked national conversation about constitutional equality and anti-discrimination law. Civil rights scholars praised the decision as a landmark victory for equal protection in the modern era. Law schools immediately began incorporating Ellen's constitutional arguments into their civil rights and constitutional law curricula. The case became required reading for civil rights law, constitutional law, and anti-discrimination courses nationwide. For LGBTQ+ rights and civil rights generally, the decision established crucial precedents requiring equal enforcement of anti-discrimination protections while preserving legitimate religious liberty accommodations. Long-term constitutional legacy. The constitutional precedents established in DeGeneres v. DOJ influenced civil rights law for years afterward. The decision's framework for requiring equal civil rights enforcement became a model for courts addressing discrimination and constitutional equality. Most importantly, the case demonstrated that constitutional expertise could emerge from lived experience with discrimination, and that the most meaningful civil rights arguments often came from those who understood both the promise and failure of constitutional protection. Ellen DeGeneres had proven that true constitutional advocacy for civil rights requires combining personal experience with rigorous legal scholarship, and that protecting constitutional equality demands the same courage that has always been necessary to defend fundamental freedoms. If you found this incredible fictional story of civil rights, constitutional courage, and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel. For more amazing tales of unexpected expertise, challenging established authority. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and personal experience can combine to protect fundamental rights. What did you think of this fictional portrayal of Ellen's constitutional expertise? Share your thoughts in the comments below. Important note: this is a completely fictional story created for entertainment purposes. Any resemblance to real events or persons is purely coincidental.